I want to welcome you to the final round of the Ames Moot Court competition.
All rise.
Presiding tonight as Chief Justice is the Honorable Ruth Bader Ginsburg.
Ruth Bader Ginsburg.
Be seated, please.
Her presence was just, tremendous. It filled the courtroom, the Ames courtroom. You can palpably sense, this kind of overwhelming respect and admiration that we all had for her when she walked into the courtroom.
I had never argued before a real court before, and one of my first arguments featured as the Chief Justice Ruth Bader Ginsburg, who's like a personal hero.
Please proceed. I, Ruth Bader Ginsburg, do solemnly swear.
She was already a hero to me because she was only the second woman justice on the court, and that, of course, was an inspiration for me.
There's not a woman in the legal profession who can say that Justice Ginsburg didn't have an impact on her career. Just the legal precedent that she set alone and her work as an advocate changed all of our lives and our opportunity.
Oyez, oyez, oyez! The Honorable, the Supreme Court of the United States of America is now in session.
Of course, it was a tremendous privilege to be able to argue in front of such a distinguished panel. You had Justice Sandra Day O'Connor, and you had then Judge Ruth Bader Ginsburg.
Didn't such a hearing occur? The district court held a hearing limited to the voluntariness of appellant's consent to transfer.
That's correct.
That is precisely the issue on which the district court did hold a hearing.
But
it was vigorous questioning from all of the panel members, but especially from Judge Ginsburg, which was no surprise.
But isn't it true, as a general matter, we don't enforce foreign penal statutes or judgments?
No, it depends, I suppose, on your meaning of the word enforce.
We don't implement them. We don't give them effect. Isn't there a general rule, though, that we don't enforce foreign country penal judgment?
Well, generally, there would be no
for
need
example,
for us to...
collect a penal fine here?
We do enforce them in extradition contexts in terms of sending the people back.
So there is no general rule that we enforce them. If we must find a general rule, it probably runs the other way.
Well, I think generally there's no reason for us to enforce them because the United States is generally concerned with whether it or not its laws have been violated.
Her questioning at Ames was very similar to her questioning in real oral arguments. She's tenacious. She was not trying to make her own point. She was trying to get an answer to her question. And so she would keep on asking.
I came away more convinced than ever of the power of this woman's intellect.
We'll now hear from respondents, and Mr. Campbell will speak first.
Chief Justice Ginsburg, and may it please the court. My name is David Campbell, and with co-counsel Jonathan Malice, I represent the Rosebud Sioux tribe.
We hoped and thought it would be Justice Ginsburg because she was the most recent appointee, and often the most recent appointee will serve as the next justice. So we were really excited when we heard there would be Justice Ginsburg.
For the same reasons, Your Honor. The sovereign immunity of the tribe precludes the federal court's subject matter jurisdiction in this case.
That was a puzzling argument to me about the United States itself would not be immune, I take it, from an action seeking injunctive relief, would it?
Your Honor, if that cause of action were brought against a government official, it would not be immune. Yes, that's the case.
The United States.
If the suit were brought against the United States itself, yes, Your Honor, unless Congress
has sovereign immunity from claims for injunctive relief, for non-monetary relief. There's no monetary relief sought here, is that right?
That's correct, Your Honor. Yes, if the action is not brought against an official itself, then
well, if I tell you, and I'm reasonably confident of this, that the United States does not have sovereign immunity from claims for equitable relief, for non-monetary relief, why should the tribe have greater immunity than the United States does itself?
Your Honor, that was this court's explicit holding in Santa Clara Pueblo, that a tribe, even in an action seeking injunctive or declaratory relief, has sovereign immunity from that underlying action if the action is brought against the tribe itself.
It felt very real at the time, and Justice Ginsburg was a sharp questioner. She took the competition seriously. I think that added to the excitement of the competition.
If you're wrong about the exclusivity of this forum, do you win or do you lose?
Your Honor,
if this is indeed a transitory claim?
we win anyway, Your Honor, because the tribe has a strong interest in adjudicating this case in order to fulfill its interest in preserving self-government and its own sovereignty.
We are unanimous that there are two best oralists, and they are David Campbell and Jonathan Malice.
When she passed, and my wife and I, someone had circulated a video of the event. We hadn't seen it for so long, but we decided to share it with our kids. We have 3 kids, including 2 daughters. My daughters in particular were so excited because they view Justice Ginsburg as such a role model. My esteem was raised in their eyes only because of the association with Justice Ginsburg. So it just reminded me and reinforced what an incredible impact she's had on so many people, and especially young women, including in my family.
We will now hear from Mr. Bowie.
The advice I received from people who had argued before the Supreme Court was that when Justice Ginsburg asks a question, it's going to be very incisive, but also she's not always clear when her question is finished. When she started to ask a question, you'd get really tense because it's like, what is she going to say? But then she would speak and you would not know whether she was done.
So you're saying that the Ames Circuit Court was wrong in that regard because that is what they said in their opinion, right?
Sorry, that the denial...
That the majority of circuits hold in the asylum context that denial of right to counsel of choice does not require prejudice.
That was an incorrect statement in the court below, Your Honor, yes. For example, when I was in law school, Justice Ginsburg was the only member of the court who had really made her career as a public interest attorney. People who have made it onto the court have careers that, members of Congress and the president think are worthy of recognition. And so for the court not to have someone with her background of having looked at the law and looked at constitutional law and said, that's not right, that's unjust, I'm going to change that, I think would have sent a really bad message to people learning the law. Because it's very easy to go through law school and learn constitutional law or learn all the other areas of law and conclude this is how it is and this is how it should be by implication. And I think Justice Ginsburg's entire career suggests that how it should be may look very different from how it is.
I can't avoid saying how deeply touched I was by the name adopted by counsel for the petitioner. I know Martin D. Ginsburg would have been so pleased to see that.
We decided to name our team the Martin D. Ginsburg team, and we did this before the semifinals, and we were a little embarrassed when we found out she was going to be the Chief Justice because we knew it might look like we were sucking up. He was someone who inspired us because of the way that he was a complete person and someone who was ahead of his time and enabled Justice Ginsburg to make the massive contributions that she did.
We are convened to hear the case of Amy Annis et al. Against the state of Ames. Mr. Liu, proceed whenever you're ready.
Thank you. The experience is seared into my memory. And this was especially the case because my team was assigned to the side of defending a Defense of Marriage Act. I knew it was going to be tough.
You said alienage is a suspect classification.
That is correct, Your Honor.
And I'm asking you what cases you base that on.
Your Honor, I don't have the cases in front of me for alienage.
We got into a discussion about the Equal Protection Clause and suspect classes and semi-suspect classes. And the justice was just grilling me.
And then you gave us for semi-suspect, sex and out-of-wedlock birth. Is there anything else? I was just wondering when I got to that point in your brief why you didn't say i.e. instead of such as, implying there were many more.
Your Honor, that was probably a decision that we now know better not to do anything.
And suffice it to say, this was not a question we had mooted beforehand, despite the hours of mooting. But looking back on that now, it's clear that it wasn't just a point about, being precise in your briefs. What she was getting at with this comment around EG and IE is that these classifications really are carefully crafted, carefully targeted, and they often, reflect years of groundwork by advocates that have, fought tooth and nail to get the right cases in front of the court at the right time and in the right circumstances. And that, of course, in many ways was a story of the arc of her own career. And I think we're all indebted to Justice Ginsburg for her pioneering work in equal protection.
She also inspires me as a justice now. I really take her philosophy to dissent really seriously. The dissent is speaking to tomorrow. So you don't write a dissent just to say, well, this is what I think. It's a little bit different. You write a dissent because you think that the law could someday be different.
After the competition, we had a little reception. And when I got to meet Justice Ginsburg, I said, thank you so much for everything you've done for women, both as an advocate and a justice. And her response was, I was in the right place at the right time, which has to be one of the few things she said that is just completely wrong. Obviously, Justice Ginsburg made the time and place where she was the time and place to change the world.
I have a slightly different experience with the Ames competition. This is the third time I have participated in such a competition. And because I read so many briefs in my everyday job, I had sworn off moot courts. I said no more. But your wonderful new dean called me, and in her inimitable way, without really twisting my arm, asked me to do this. And so I am here because of Dean Elena Kagan, and I must say it was a treat. I thoroughly enjoyed it. And now the hour is late, so the court looks forward to meeting all the participants shortly, but the court is adjourned.